And just takes a minute here for people to start to appear, and then I have to manually do the thing on the Instagram.
No worries. I'm familiar.
There we go. All right. Hey, we got people piling in. And it's going to
All
be a
right.
lot of interesting conversation today. Today we've
Oh
got
boy.
personal bankruptcy attorney Adrienne Hines, who is going to be talking about bankruptcy and small business bankruptcy. Because as we're going to get into in the world of the smallest of businesses, it's all tied into personal financial stuff anyway. So I'm going to kick things off by running our intro, and then we're going to get back in here and start our conversation.
I'm David C. Barnett, and you're tuned in to Small Business and Deal Making, the podcast, YouTube channel, and blog where I talk about buying, selling, financing, and managing small and medium-sized businesses while controlling risk. So if you're looking to take control of your future through buying a business one day, or if you already own a business and you're looking to grow or exit, you've come to the right place. I talk about interesting things, I talk to interesting people, and I answer your questions every week right here. So be sure to hit like and be sure to hit subscribe, and let's get to it.
Are you a small business owner that's thinking about exiting your business now or in the next few years? My team and I are here to help with our unique zero commission program that we've been using since 2016. We can show you what your business is worth, prepare the package you'll need before you meet your first buyer, even run a confidential online advertising program for you just like business brokers do. And we'll coach you through the whole process, or you can hire us to manage it all for you, including coordinating your whole sell-side deal team. Head over to howtosellmyownbusiness.com to learn about how my team and I can help you get ready by watching a series of videos we prepared that explain each step in detail. And if you're ready or just curious to learn more, reach out to us and we'll get you started or schedule a call to answer your questions. I look forward to meeting you and learning more about your business. All right, Adrienne, how are you today?
I'm doing great. How are you doing?
I'm well. We've already got viewers here piling in. Victor from Nottingham says that he's given the show a like, and I would encourage everyone out there, on whatever
Yay.
platform you're looking at, if you're looking forward to today's conversation, give us a like, leave us a comment. It helps the algorithm show people that this is great content. And I will remind everyone that Adrienne is a bankruptcy attorney in the United States, and so the conversation that we're going to be having here today is about laws that are in the United States, in particular, people that are in the U.S. Again, bankruptcy, I think, is pretty much common to most countries around the world, but the rules specifically are going to be different from one place to the next. And so let's get started by learning a little bit about you, Adrienne. Can you give me a little bit of a background on who you are and how you ended up practicing this specific area of the law?
Yeah, thank you, David. My name is Adrienne Hines, and I am a bankruptcy lawyer in the state of Ohio. I live in Northern Ohio, very close to our Canadian friends. I can zip over there very quickly. So I'm a bankruptcy lawyer, and I've been practicing for about 28 years now. I didn't start off as a bankruptcy lawyer. I started off as a workers' compensation injury attorney in the state of Ohio. And our system in Ohio just is not that great for injured workers. And along the way, I realized that, people who are living paycheck to paycheck, who, are struggling, a small little problem can take them off their path. And so I started to do bankruptcy work in order to help my own clients. I had the benefit of interning with a bankruptcy judge when I was in law school. I never thought that would be my path, but I circled back to it. And honestly, I realized and I found over time that this is the area that I just absolutely thrive in. I love bankruptcy. I love talking about bankruptcy. I know that's absolutely crazy for most people, but I'm very enthusiastic about this because I understand what bankruptcy is, why it exists, and I think it's really important for everybody who's coming in here to hear that the reason that bankruptcy laws generally exist is so that people can open businesses, so they can take risks, so you can get out there, you can try it. We all know that success only comes from failure. And so bankruptcy laws are ingrained to encourage us to start the businesses and to take the risk. So if you understand bankruptcy, you have the ability to harness a little bit more risk and a little bit more energy moving towards what it is you're trying to do. So that's what I do.
So this is great. You specifically said that you're practicing in Ohio. Do the rules of bankruptcy change to any degree from one state to the next?
They do, because in the United States, we have two major issues that we have to deal with when we start evaluating bankruptcy. And the first thing we evaluate is a household income test. So any individual or business owner as an individual who's filing a bankruptcy, we generally have to analyze some information about their household income. And that can be different from state to state. We also have things called exemptions. So when you file a certain type of bankruptcy, one thing we all think about is the fact that we might lose something. So a Chapter 7 bankruptcy is technically called a liquidation. So what we can protect, most people don't have anything liquidated because we protect out most of what they've got. But those protections are different from state to state. So whether or not
Okay.
your house would be safe in Illinois is different than whether that house would be safe in Ohio. But I do want to say that outside of the exemptions, something that's really important for your audience, in the United States, if more than 50% of your debt is business debt, then you do not have to qualify under the income category in order to proceed forward. So it's actually a pretty nice thing. There are advantages built in for people who are struggling because of a business failure. But those things are what are different.
Okay, so let's expand on that a little bit more because when people get into business, whether they buy a business or start a business, they are going to typically incur some debts. They are going to, use a credit card. Maybe they're going to borrow money from a bank. Maybe it's going to be an SBA loan, and all of those different lenders for most small business instances are going to require the owner to sign their own name onto that loan.
Right.
And so it all ends up being personally guaranteed by that individual. And so what you're saying is if more than half of the person's overall debt is tied in some way to a business activity, then this is going to make it easier for them to go down this road?
Yes, and there is a caveat though that really catches people and doesn't seem exactly fair. And that is when we're doing that balance, that 51% business versus 49% consumer, our mortgages and our car loans go into the consumer category. So
Right.
ironically, if we have a $200,000 mortgage and we have $180,000 in business debt, we still don't have enough business debt to offset the consumer debt. So it's something to pay attention to. But this is really what oftentimes happens is when we start a business, you start a business, I start a business, we pay $99 and get an LLC, but we walk into the bank and the bank isn't going to lend our LLC money because it hasn't been around. It hasn't shown its ability to earn money. So as we're starting our businesses and in those early times, we are personally guaranteeing those debts. It's really in our names. For that reason, I am as a consumer bankruptcy attorney, I file bankruptcy a lot for individuals, husbands and wives, small partnerships that have personally signed and are personally responsible for the debts of their business. And that's when we are analyzing what their options are. And when we're analyzing their options, that's what we have to do is we have to figure out how we're going to navigate them based on their debt load.
Okay, so I'd like to ask another clarifying question on this topic because a lot of the times, particularly when a business is new, the business itself under its own name can't qualify for a lot of different kinds of credit facilities. And so what will happen is a small business owner might take maybe they have 3 credit cards. They might take one of the credit cards and say, I'm going to use this one for business stuff. And it kind of becomes their business credit card, but it doesn't have the business's name on it. And
Right.
so if that person ran into trouble in this scenario, would they be able to say, this is the card I use for business and I can show it's all business expenses? Would you count that as a business debt or would you still put it into the consumer pile?
In Ohio, I would be able to count it as a business debt because I know
Okay,
that we can. These are the types of things that could be different from jurisdiction to jurisdiction,
gotcha.
from from state to state, and it's not always from state to state. It's from federal bankruptcy jurisdiction to federal bankruptcy jurisdiction. So the philosophy of the judges in your court system is
Okay.
really going to tell us a little bit more. So that's going to be case law, right? The case law in your state might be a little bit different than the case law in mine. In mine, at this point, we are allowed to include, if we can show that it was business debt. I use my private credit card, but I paid for the convention or the seminar for my business, right? As long as you can show those things, that's generally not that big of a problem. But
So
I
this is
don't know
really
how, yeah.
well, this is really insightful because the bankruptcy laws are federal, but there's
Mm-hmm.
an impact on the state that you're in. And what you're saying is that even the different jurisdictions for the bankruptcy court may be interpreting things a little bit differently.
Yeah, they absolutely do. Just like, when you hear in the United States different, oh, we're going to file in the Southern District of New York because they're really, blanket friendly,
Okay.
right? We're going to
Okay.
file over here because they're, not so friendly. Texas is a really popular place for bigger businesses to go because the Southern District of Texas is well known to love corporations when they're going into bankruptcy, offer lots of, incentives for them to try to bring their business there. The problem is with consumers, we're stuck with where we live. So we are stuck
Okay.
in the jurisdiction where we reside. If we're not a big corporation, an S corp, right? We're individuals, we are stuck with the jurisdiction that we have. So the first thing we have to look at are state boundary rules on the income limits and the exemptions. And then the next thing we look at is the territorial, rulings of the different federal courts. So in Ohio, we have a northern federal district and a southern federal district. So
Okay.
things we do in the northern are different than how they do things in the southern. So we have state borders that control income limits and exemptions. And then we have the different court philosophies, which are going to influence a lot of different factors, that are necessary to understand what you're going to do.
So this is really an area of law where someone needs to have an attorney who is local and familiar with things where you are.
Yeah, and it's really important. As much as I love being on all of the socials and doing what I do, the irony is that I can only file bankruptcy for people who live in Northern Ohio because that's where I practice, that's where I understand, and that's where I know very clearly how to navigate my clients safely. And for that reason, it really is important to turn towards your own community to find a lawyer. But yes, it's very nuanced, and it's very unique to your general geographic location.
Okay. So let's talk about the process because I think there's a couple of different ways in which a small business or a consumer can go through the bankruptcy process, and they're referred to by chapter numbers. Can you kind of give us a quick overview of
Mm-hmm.
that?
Yeah, so the primary chapters of bankruptcy for businesses and individuals is going to be the most coveted, and the one most people want to be in is going to be a Chapter 7. Most people want to be in a Chapter 7 bankruptcy because it's very fast. You get in and you get out, and you get to completely discharge without paying back your general unsecured non-priority debt, right? So that's going to be, well, let's talk about what priority debts are. That's going to be taxes,
Sure.
child support, alimony, student loans. Okay, it's
Okay.
not that. If it's not that, it's more likely to be going away. So if it's not a priority and it's not a secured debt, like a car loan or a mortgage, it's
Right.
probably going to be the type that goes away in bankruptcy.
And
Lawsuits,
things
payday
like the
loans,
loan.
credit cards, loans, SBA loans, all of that stuff. Stuff where you've been lent money and they haven't taken something in return, right?
Okay.
That's generally the kind of debt that's going to go away. And that's going to go away straight away in a Chapter 7 if you qualify and you're able to move forward with that.
And things that are secured, like a loan on a truck, for example,
Mm-hmm.
that is still going to be resolved, but it's probably going to be through the lender getting the truck.
Well, that's only if you want to give it back. If you
Okay.
go into a bankruptcy and you have a truck and you want to keep the truck, we have to do two things. First, we have to analyze it to make sure that you don't have too much equity in it. That's the big issue. So if you have a truck that's worth $20,000 and you owe $10,000 on it, that's a $10,000 secured loan. But that means you have $10,000 in equity in your truck. And that is what we need to have an exemption for in your state. In my state of Ohio, our exemption for your motor vehicle, the equity in your car or truck, is going to be different than Illinois or anywhere else. So it's really dependent upon your state. So the first thing is we analyze, if you're going to move forward with a bankruptcy, we try to figure out if you do have meaningful equity in something, because it could be at risk and we need to come up with a plan to protect it. But more likely than not, people go into a bankruptcy and they have a negative equity and they are upside down. They owe more than their truck is worth. I just talked to a client this morning. She owes $21,000 on a GMC Terrain that's worth less than $10,000 today. So when she files her bankruptcy, not only will she be getting rid of the credit cards, right, and the personal loans and business loans, but she's also has the opportunity to surrender that car without penalty in a Chapter 7. And the thing about a Chapter,
because the extra debt beyond the value of the vehicle, it technically becomes like sort of unsecured, so it gets wrapped up with the credit cards and things.
That's exactly what it is.
Okay.
A car loan, in that case, the car loan's only secured to $10,000. The remainder of it is unsecured, which is why you can give them the car back and the remainder goes away. So that's a Chapter 7. That's the first type of bankruptcy. It's ideal. It's what really everybody wants to file, David. But the problem is, again, these income limits. So in order to qualify to file the easiest bankruptcy, your business has failed, you just want to get the heck out, right? You want to try to go into a Chapter 7. The first thing we have to look at is that household income test to see if you pass it or fail it. If you fail the household income test and your business debts are not greater than your personal debts, then you do not have an option to file a Chapter 7. You must look at another bankruptcy. So Chapter 7 is first. It's most desired. It is the easiest one. It is the least painful, but it requires that you not only meet income tests, but there is also this asset test. So we always have to be looking at the equity in your assets. That's Chapter 7. The second most common type of bankruptcy that most people would then turn around and file if they can't file a Chapter 7 is going to be something called a Chapter 13. And a Chapter 13 is a repayment plan. It's you saying, your income's over the limit. And so the court says, look, if you're over this income limit, if you're a family of 4, you want to try to keep your business going, right? But you have more personal debt than business debt, then we're going to reorganize you so that we can, figure out what the most important things here are to pay. And based on how much money you're making every month, we're going to calculate out what you need for your expenses, and then everything else is going to come to us to start keeping your creditors happy. So that's a Chapter 13. It requires paying money back. And you can see that when I said a little bit earlier, if you don't have to take that income test, if your business debt is more than 50%, then it is so important to understand that you have a lane in the Chapter 7 bankruptcy, because a lot of lawyers don't remember this. A lot of people don't understand this. And the business debt is really important to analyze deeply. If you're in a Chapter 13, that means you are filing as an individual. You've personally taken on this debt. You're either over the income limit and trying to get out of this paying the least amount possible, or you're trying to reorganize and trying to save something. You want to try to save your business. We can do that if you can come up with a plan that works. The third type.
Have you ever had somebody purposefully take on more business debt if they could in order to move the needle enough to go into 7 versus 13?
I haven't had anybody who's had to do that, but I've certainly been prepared to help my clients understand that concept. I've
Okay.
never had somebody who was on the edge close enough that there was something that they could take on, but I certainly keep an eye on that. But that's a good question. It's a really
Okay.
good question. So Chapter 13 is limited to debts that are under $500,000. So if you have more than $500,000 in unsecured debt, or if you are a larger, it is an actual business, your business is filing bankruptcy. That's what a Chapter 11 is. 11 is either for the actual business, not you personally. It's your
Hmm.
business filing bankruptcy. It's bigger. It's the one that has the debts. Or it's an individual who has high debts, over $500,000 in debts. Those people
Okay.
have to go into a Chapter 11, just because there's just a whole different level of analysis there. So those are the three types of bankruptcy. Most people are generally navigating between either a Chapter 7 or a Chapter 13. Most people want to be in a 7 in the United States. They will reluctantly go into a Chapter 13 with no other options, but that's kind of how it works. And those
And,
state rules are the exemptions and the income amounts for your household size.
and is Chapter 11 the one where there could be a reorganization where some debts are taken care of so the business can carry on under a new plan? Is
Yes,
because I think that's the one
absolutely.
we hear about that one most often in the news, right? When
That
you hear
is the
about
one we hear. Johnson and Johnson, Rite Aid. President Trump. People say, "Well, he filed 6 times." No, 6 of his businesses filed Chapter 11. Donald Trump has never personally filed, so that's the
okay.
difference, right? But Donald Trump would have to file if Donald Trump himself. Let me pull back from him. Rudy Giuliani had to file a Chapter 11 bankruptcy, not because he was trying to reorganize a business, but because he owed $20 million to, after a lawsuit. So he had no choice but to go into a Chapter 11. But they're pretty rare. We don't really see that unless we have really high debts for an individual.
Okay. You meet small business owners that come in and talk with you when they're in trouble. What are some of the most common misconceptions they have about the process? Maybe they've been learning about it in the news or through movies, and they come in to talk with you. What are some of the most common things that you have to educate them on?
I would say the number one most common thing that I have to explain to people is the fact that having an LLC does not protect them. They most often come to me thinking that just their business can file bankruptcy and it won't personally affect them. They think that's the
Mm,
case because they created an entity called an LLC. So honestly, a lot of the conversation I'm usually having is explaining this concept of personal responsibility on the debts and going through that type of thing. Obviously, the biggest misconception about bankruptcy is that it's the end. It will ruin everything. It means everything is over. And that's absolutely not true. I mean, the purpose of a bankruptcy is to give you a fresh start. It's to get you back up on your feet when you've fallen on your face. So I think the biggest misconception is that it's gonna ruin your life, when in fact, there's a time and a place for everything. And if this is the time and a place for a bankruptcy, then you need to be open to it and explore it, because getting through your debt quickly is what really matters, especially for people who want to get back out there and start another business. I encourage it. It's why these laws exist. And I just want to remind everybody that we would not have Disney World if bankruptcy didn't exist. A lot of people don't realize that Walt Disney and his brother started a company called Laugh-O-Matic initially, and they had to file bankruptcy because they were not the amazing studio that they grew into. And it's really interesting to understand that we would not have any of this Disney anything if bankruptcy laws didn't exist, and that's why they exist. That's truly why they're here.
We've got a kind of an interesting question, just asking if you're aware of any countries that don't have such a setup available to people.
Well, I think a lot of countries don't have bankruptcy laws that would even be familiar to us. But I would say that's largely because other countries our country is a truly capitalistic society,
Mm.
right? Our economy is capitalistic. And when I say our government, our society needs us to go out and start businesses, that's really the point. So I would say, in countries where we're talking about the ability to get rid of unsecured debt. So in countries that um, don't 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 have democracy, right? Democratic ways, then they don't have the same type of protections against consumer lenders. It's not really their goal to encourage businesses. It's their goal to encourage workers. So the philosophy of the country matters in terms of who's going to have these laws. But America, Canada, those of us who are really out there who know that we need to get some business done in order to keep things going, those are going to be the countries that are going to have robust laws. And they're going to be countries that don't protect its citizens from these lenders very well. They're more likely to have these laws so that there is a fail safe. There's a
Okay.
fire chute, right?
What are the early warning signs, do you think? Like if someone's in business and they have a spidey sense going on that something might be wrong in their business, what do you see are sort of the early warning signs that people really need to pay attention to?
Like it's not rocket science, right? I mean, we understand when things are starting to not go so great. I think the biggest problem people have is that they take their risk out so far and have absolutely no understanding or no plan for what might happen if that risk fails. And I do think that when you can look at your profit and losses. You can start to look at your vendor costs. You can start to look at all of these things. And when one is starting to increase above the other, especially when it's not going in the right direction, that's when our spidey senses start to kick in. If you are draining your resources, if you're thinking about liquidating, your business assets or your own personal assets for this, obviously you're starting to move into dangerous territory. Thinking that you're just going to get a big deal and pay off all of these things is really what gets people into this. And, to some extent, that's okay. Again, we do need some risk here. There's a reason we have access to these types of unsecured loans, but it's important to understand what the fail-safe is. And I got to say, I think that if you're at the point where you're looking at a merchant cash advance, I personally think that for a small business owner, that's a big red flag. If you're moving in that direction, it's as if an individual person is having so many financial problems that they're going to a payday lender. I believe that if you're going to a payday lender as an individual or you're going to a merchant cash advance as a business, you are probably doing something wrong at that point. You should be talking to a lawyer who understands more about bankruptcy so they can at least give you some information.
I've got a great video that I made a few years ago at a whiteboard where I explained just how expensive merchant cash advance really is. Because the way that it's presented is they present it saying that you're going to pay back, for example, 25% more, and it makes it sound like you're paying 25% interest, which kind of sounds like a credit card. But the reality is that the way the payments are calculated and the way they take them from you, it's actually in the hundreds of percent rate of interest. And so after our interview, I'm going to update the show notes and I'll include a link to that video. Maybe we'll put it in here as a card. But it really is worth watching. In my own experience, I find that when people are doing well in their business or when they are really engaged with their business, they're eager, for example, to get their books at the end of the month, to get the bank statement reconciled. They want to see their income statement and their balance sheet. They want to see how their progress is going, if they're going to hit the targets they've set for themselves for the year. And then something happens where people become disinterested in this information. And I think it's almost like some kind of self-preservation thinking sort of thing where people know it's not good. And so then they are not interested and they stop looking. It's almost like when people, back in the day when all the bills came in the mail, it would be like people like choosing not to open the envelopes that came from the bank or something because they know it's bad news.
Well, not back in the day. I mean, as recently as this morning with my first client this morning. I mean,
Well, a
that's
lot of
really
this is
true.
electronic now, I guess is the point I was
Yeah,
trying to make.
yeah.
But
No,
yeah.
but for real, I mean, I think you're very insightful when you say that, David. And I, honestly, I hadn't really ever put those two things together, but that is absolutely true. The reality is whether you're an individual person or whether you're a business, right? When you stop opening up the bank accounts, when you stop reconciling, when you stop being, enthusiastic or excited about seeing what's coming in and making sure you understand what's going out, that is a red flag. That means that you're starting to check out because you understand financially things are not going well, and it's a time to start paying attention, not to back off. You still have options at that point. The farther deeper you go, the longer you wait to open that mail or open those emails or catalog all that stuff, the worse it's going to get. And then what happens is people ignore, and then they come to the table and they're so embarrassed. They're not going to
Yeah.
pick up the phone and call somebody like you for advice or me for advice. They're going to like cruise around on the internet. And they're going to be like, I'm desperate for money for my business. And then they're going to get the merchant cash advances, and they're going to get the payday lenders. And it's the same thing. Payday. And here's what's so important. There are no, the usury laws are used to be what were in existence in the United States that would limit the caps on interest. And I don't think most people understand that those are gone. Like I even thought they still existed as few as 5 years ago. Even I didn't understand how much that had been chipped away. And so when we think back, we think, wow, back in the days of the organized crime and the mafia bosses, they were, we put laws in place so that they would not loan shark, right? So we all thought loan sharking was illegal. It categorically is not anymore. And so when we're talking about bankruptcy, and this is a big reason why I will defend the process of bankruptcy, it's because most of us don't understand the very predatory manner in which we've gotten into this debt. We have let these lenders charge us hundreds and hundreds and hundreds of percents of interest. Most of my clients have no idea their payday loans are 400%, right? They don't understand it. And so they can't make rational choices if they don't even understand the depth of their problem. So to recognize that consumer lending, at least in America, and probably in your country too, is very predatory. That is why bankruptcy exists. That's why taxes, child support, alimony, student loans are not really going to go away. That's why secured debts are different, because everything else is being lent, outside of a lot of the laws that used to be in place to help us. And so we gotta navigate this ourselves, and we got to be
Well,
open-minded about it.
and even, even to this certain point, like national laws almost are kind of not as important anymore, because I know some of these predatory lenders set themselves up, for example, in Caribbean countries,
Mm-hmm.
and they'll do it over the internet, and you
Yeah.
put in your banking information and give them permission to take the payments out. Like,
Mm-hmm.
the authorities of your country literally don't have jurisdiction over that outfit because they're just outside the country.
Yeah.
Um, we've got a great question here from Rob. He asks, "Do you have experience? Do you have experience of an owner selling their business or intellectual property as part of the Chapter 7 process?" So you mentioned it was a liquidation of debts, but I guess the assets get liquidated too. Can you tell us a little bit about that?
Yeah. So when somebody first comes to me, we're looking at the assets. What is left of the business? Was this a coffee shop? Did you have a cash register and table and chairs and a barista, cappuccino maker? Did you own the real estate? So when they're coming to me, we're trying to figure out where they are in this process and what they still have. Of course, if they're closing the LLC, they have to close it down, and they have to, they have to protect. They have fiduciary duties on the liquidation of the business assets, right? So that has to be done. And then we're going to figure out what's left, what you're trying to keep, what you're trying to do. We're going to need exemptions in the state of Ohio for it. We're going to need actual exemptions that are going to cover it. Most commonly it's coffee shops and small little restaurants and truck drivers and those types of small I seem to be filing bankruptcy for a lot of small car, like tiny little car dealerships, right? But this wasn't my client, but I was in a bankruptcy hearing once, and another person went ahead of me, and it was somebody who had written a book that had been turned into a very popular movie.
Okay.
And so that person had royalty rights. And in the filing of the Chapter 7 bankruptcy, those royalty rights were an asset. And so they ended up having to surrender those royalty rights. Their lawyer should have walked them through liquidating those themselves. So that's what's important, is understanding what's at risk, how to liquidate those things yourself to maximize your benefit, right? So
Well,
that's a
let's
lot of
talk
what we
about that.
do.
Let's talk about that. If you have assets that you think might be worth 100 grand, but you have 250,000 in debt, is it worthwhile for that person going bankrupt to try to maximize the selling price of those assets, or hey, none of the money's going to come to me anyway. It just doesn't matter. Like what is the
Yeah.
correct attitude?
Well, and that's a good question, because it really depends. It really depends on the balance, right? And it also depends on what it is. Obviously, if we've got $200,000 in debt, we've got $100,000 worth of, um, you know, uh, 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 intellectual property. We can sell it for that. The question is, do you want to try to protect that and save it? Do you want to keep it for yourself? Because if so, you can do that. That's when we put you in a Chapter 13. If you can file a Chapter 7 bankruptcy, but you have a piece of equipment that you don't want to lose, that you don't want to liquidate, you want to try and start a business again, and you're going to need this. That's when we have to look at a Chapter 13. It's the second
Mm,
reason we look at a 13. So you can go through, and what you end up doing is you have to pay that which your creditor would have received if you had filed a 7. So if you have
okay.
$200,000 in debt, and you have a $100,000 thing that's really valuable to you, that's very important, that you don't want to lose, you can go into a Chapter 13 and you will have to pay $100,000 over 5 years, because that's the value of your thing. Okay. You don't have to pay 200 if you can't afford it, but you have to at least pay enough to keep the thing. So then that becomes a decision. How important is this stuff to you? Do you want to try to keep any of this for later time? If not, we can file bankruptcy. I will say we can file a Chapter 7 bankruptcy and let the trustee liquidate everything. But it's a lot. You will have had to have been, you had fiduciary duties to any lenders who had UCCs and all that stuff. So you would still have to have those things in your possession, right, when you go into the
I
Chapter 7.
I could also see maybe this is a strategy that somebody could find someone for which the intellectual property held value and try to negotiate into it. Like, hey, if you want to come buy this IP and then hire me to come work for you, like almost kind of leverage that asset
Yes.
into getting a job or something. That could
Yes.
be another sort of positive outcome for the person going bankrupt as well.
Absolutely. And I think the more open you are to understanding, kind of the possibilities here, the more opportunities that will become available to you. That's exactly true. You can surrender everything in a bankruptcy, and your bankruptcy trustee is going to go try and sell this stuff or this thing. You can offer. You won't have the financing, but you can get a business partner to go in and finance it. You can create an agreement with your business. You guys can create a business again, but it has to be sold and transferred for fair market value. That's the issue. You can't just take something you own
Right.
and hand it to somebody else, but somebody's going to have to pay fair market value for it, if anyone is going to want to keep it. But yeah, and you can usually negotiate that with the trustee. You can
So
use this
so
as
hang
an
on, hang on.
opportunity. Yeah.
We're talking about this person, the trustee. Let's get it clear who this person is. So if you want to go bankrupt, you go to a bankruptcy attorney, you
Correct.
file with the court, whatever
Mhm.
the under which chapter you want to file. And then if the court approves the plan, then the trustee is the person who kind of executes the plan. Is that fair to say?
So there's different. A Chapter 7 trustee
Okay.
is there. Their job is to simply represent all of your creditors collectively and ensure that you have not committed fraud, to ensure you are who you say you are, and to ensure that you've listed everything. And it's their job to take anything that's non-exempt. They take anything that's non-exempt, they liquidate it themselves, they get to keep a portion for their fee, and then they distribute the proceeds pro rata to your creditors, right? So that's their job. And in so doing, they are an independent contractor. So they are appointed by the U.S. Department of Justice. That's their fraud oversight, right? But they are businessmen and women. Their job is they get the first 25% of the first $5,000 they find, and so it's a sliding scale. So the more they
So they're trying to sell things for the highest price they can.
They are trying to find anything that's not exempt, and they're trying to sell it for the highest value that they possibly can. But there's general ways that they go about doing it. I know how my trustees, in Toledo, I know there's 5 of them. I know how they're each going to kind of handle this, and collectively how to explain this to my clients, what they might expect. Again, these are the types of things that are different. I know that if we file, I can give one of our trustees a call and say, hey, listen, I just filed. We've got a small business. We want to start making a deal. Don't get ahead of anything. Let's start talking. And so those are the types of nuances that we do. But the trustee's job, whether it's in a 7 or a 13, is to collect assets, either collect your money in payments in a 13 or collect non-exempt assets to liquidate. In both situations, the trustee is representing your creditors collectively. They aren't the court. You probably will never see your judge. The judge is the independent, judicial body. The trustee is separate. They are paid separately. They work separately, and they represent your creditors. And that's why you don't really navigate with your individual creditors very much. They just kind of go away, and you're just dealing with the one trustee as a general rule with your unsecured debt.
Okay. We've got a question here about credit scores and credit reporting. And Dave asked, does business chapter 11 affect the business's credit score, DUNS, or some other type of thing like that? But I think we should expand this beyond just this specific question. What is the impact of this process on different credit scores or reports?
Yeah, that's a great question. And the answer is, of course, that bankruptcy is going to materially affect credit scores, whether it's the businesses or whether it's the individuals. But here's the thing I think most people don't really understand, and thing I think is very surprising. In my practice, half of my clients who file for bankruptcy, their credit scores will go up because
it's so bad.
Because it's so bad. Because it's so bad, and it doesn't have to be really bad. In the United States, in my general area, what I see is individuals' credit scores are going to pop up to about 600, 620. So anyone under 580. And yesterday I talked to 3 people who all had scores in the 400s, at least for their personal scores. All of them are going to experience a bump up. And so where you are in the process really matters. How far where you are when you make your way to the lawyer. For my clients who still have a 700 credit score, when they come to me, it's artificial because they're coming to me. They're coming to me because they have unmanageable debt. And what they've been doing is they've been robbing Peter to pay Paul, keeping their credit score artificially high. So those are usually the people who are like, what's going to happen to my credit score? And the answer is, well, you got payday loans and you cannot rob from Peter to pay Paul anymore. There's nothing left. So your credit score is going to go down anyway. We're going to, it's time for us to take control. We're going to take control of this broken car, and we're going to put the blinker on. We're going to put the gas on. We're going to take it over to the side and stop the car and fix it. That's essentially what bankruptcy is. Bankruptcy then allows you to get back on the highway. But the credit score issue and, what is this going to do is really relative to where you are when you finally realize that you're in trouble. And understanding how to increase it again and how to navigate that on the other side is really important. From a personal standpoint, personal individuals can increase their credit scores back to a 720 within 12 to 24 months. You're depending on what's going on. Yeah. I don't
How
think
long is the notation on there that you did go through the bankruptcy process?
the notation is on your credit for 10 years.
Okay.
My clients, they can absolutely get back to a 720 within 12 to 24 months, and they can qualify to buy a home, real estate, in 2 to 4 years. And so when we say how long is a bankruptcy on your credit, I'm not sure that's really the question. The question is, how quickly can you rebuild and turn around and leverage again to get back into the game? And the answer is a heck of a lot more quickly than if you're sitting in your misery, moving the shells all around. If you're not acknowledging where you're at, you're never going to get to a place where you can have a good credit score and actually be successful in leveraging who you are.
Yeah, yeah. You got to, at a certain point, if there's no way you can service the debt or have any kind of reasonable plan to repay it, then the only other way to resolve the situation is to go through a process like this to just unload the debt and just have it disappear.
Most people do not understand that, David. Most people really honestly believe that there just has to be a way, that they're going to find a way to pay it. And that mentality keeps them in it too long. It wastes time and opportunity. And that's why it is so important. That's why I'm out here on all the social media, spending all my time these days talking about bankruptcy and trying to desensitize people to the word, trying to make people understand that there's a lot of myths and misconceptions. Bankruptcy is probably one of the best options for people who have unmanageable debt, whether you have a small business, whether you are an individual, whether you are an elderly person on Social Security. It is an opportunity to move through this fast, because time is money. We got to start that business again. We got to get back
Yeah.
to doing what it is is going to help us achieve the dream that we're trying to get to. And the longer we sit in it and wait, the worse off we are. The worse off we are.
It comes to being assertive about decision making,
It does.
about sitting down and really analyzing your situation and deciding what makes sense to you. I've got a couple of questions here from Big Mike. It says, can a student loan be discharged in bankruptcy? And I
That,
think you mentioned it was a priority debt earlier, didn't you?
I call it a priority debt. That's very, very, very astute of you, David. But it's not technically a priority debt, according to the United States government, but it is treated as one because they had such a tremendous lobby 20 years ago when we overhauled our laws. And so the reality is that student loans are, as a general rule, non-dischargeable. For a period of time over the last couple of years in the United States, there was a lot of activity trying to move forward some student loan relief. And under Biden's administration, he had given the Department of Justice instructions to streamline the process to get rid of student loans for those people who would already qualify. He couldn't change the parameters. And to qualify to get rid of your student loans, you really have to show tremendous need and an inability to ever be able to support those payments. So a lot of times it requires significant poverty and or disabilities. And frankly, based on based on the political climate in the United States, I don't think we're going to get any additional relief on student loans. I think any relief, any easier that it got over the last 2 years, and I wouldn't say that it was all that much easier, I'm pretty sure that's going to go away. So student loans are generally, as a general rule, no, they're non-dischargeable for most people in the United States. If you are on Social Security, if you're disabled, there are already waivers that you can apply for. So
Right.
I want people to know that. Yeah.
I've got an interesting question here from Rob. Says, have you seen a way for the personal guarantee of the SBA 7A loan to be released during a business sale when the price of the business being sold is less than what's owed? So this, well, I would have another question. Could you even do a sale without the bank becoming involved in that scenario? You'd probably need them to approve this transaction, wouldn't you?
I would assume so. I'm not a business attorney, so I'm not navigating the sale of businesses very much. But what I can say is that SBA loans are dischargeable in bankruptcy if the proceeds of the SBA loan were used for legitimate business purposes. But as it relates to the sale of the business, I don't know, because that's kind of outside the bankruptcy side. If that person sold the business but was still personally responsible for the SBA loan, I haven't had a situation like that. Obviously, if you're selling the business, you have to make accommodations for it. But I have filed bankruptcy for a lot of people who had SBA loans that and businesses that failed, and so they had to personally file bankruptcy, and we are able to get rid of those loans in bankruptcy. Mm-hmm.
So I'm not an attorney, but I talk a lot with people who do business deals and with attorneys. And from my understanding, which is not legal advice, that the attorney representing the buyer, Rob, in their documentation, they're going to say that they expect to get free and clear title to the business and its assets on closing. And in order to do that, the lender, the SBA lender, would have to be paid in full. And if they aren't, then they won't discharge their loan. So the seller's got to make some kind of arrangement with them in order for the buyer to get what the buyer's contracted for. And so this is like a short sale scenario. And, it really would come down to probably talking with that lender and figuring out what is easiest for them, because the last thing that they want to do is end up owning the business or anything, right? Like, so again, it comes down to how much can you deliver through the deal you've found, and then what can you work out with them afterwards. It's going to be a mess.
I will say that there's some power in leveraging the concept of bankruptcy when you're negotiating with your lenders, right? Like, very often I'll call up the bank and say, hey, I got so-and-so in here. We're just struggling, and we're gonna, everybody knows if I'm making the call, if it's coming from Adrienne Hines, that I am the bankruptcy attorney in our region. They know really what we're talking about. But I'll say, listen, I'll file bankruptcy. And sometimes we can use that as some puffing. We can push the envelope a little bit. But at the end of the day, I would say that, banks and companies tend, if you're dealing with them from the business side, they tend to be a little bit more amenable to starting to work out deals, knowing that bankruptcy is a complete possibility on the table. They do that in businesses more so than they would do that personally. If you're behind on your mortgage, it's shocking to me how hard it can be to get somebody on the phone to navigate a deal or something like that. But in my experience, businesses and banks and those types of lending situations do lend well to being able to negotiate. I've represented some banks in our area over time for people I wasn't filing bankruptcy for, but that's absolutely possible and something everybody should be considering if that's what they're looking at.
Do you think that might be because maybe a house, from the point of view of collateral, is a much more solid and tangible thing versus a business, which is really, there could be a lot of goodwill value that could just simply evaporate if the business stops operating. It's harder to sort of repossess and try to sell a business, especially under the SBA arrangement where they lend versus the purchase price rather than the tangible asset value.
Yeah, absolutely. I mean, and it's because we're usually talking about a bit more money than we are talking about usually with individual debts, and we are oftentimes. Yeah, I mean, absolutely. It's because it's a business, and somebody from the bank can't just come in and start running your business. They want you to do it, and they want to get as much out of you as they can. They know what bankruptcy means. Bankruptcy could mean they get nothing, right? And so they understand it's not a house. They understand it's not a credit card. They can't ruin your life personally as much. If you're willing to file for bankruptcy, they want to try to work with you, because businesses are really what banks, that's who they want their clients to be, and they understand businesses go under, and they have to find ways to ride that surf as well. And so my experience is we're almost always able to start negotiating with reasonable banks, local banks.
Awesome. Adrienne, I know you have a hard stop with another meeting here today, so I want to thank you very much for taking the time to join us. For people that are interested in learning more, or maybe even if they're in Northern Ohio and they'd like to reach out and talk with you, how can people get in touch with you?
Yeah, I do want to say that I have a very prolific and popular social media platforms across all of the socials. My username is at the Ladylike Lawyer. I'm on TikTok and I am on Instagram and I am on YouTube and all of the things. I have thousands of videos and I would encourage people to find me there. My website is www.theladylikelawyer.com. If you go there, you can, if you're in Northern Ohio, you can come to me. I do have a network of lawyers across the United States that we pair you up with if you're looking for one, whether it's, whether you are a small business owner or you're a regular person, we can set you up with an attorney near you who offers free consults. And, this whole time I've been talking about how important it is to turn inward to your local community for a lawyer near you because of the nuances and the quirks from going from jurisdiction to jurisdiction. So I really want to talk the talk and walk the walk. I don't think anybody should pay to talk to a bankruptcy lawyer. Please hear me say that. But if you are a small business owner, you need to be aware that most consults are about 30 minutes. And if you know that you need to deal with a bit more business stuff, you might want to say that and be prepared to just pay a little bit, maybe $100 to have an extended conversation. But it's really important that you take the time to stop and talk to a bankruptcy lawyer because, most of them are free. And talking to a bankruptcy lawyer just for 20 minutes can give you tremendous insight as to where your finances are going, both personally and with your business. So, yeah.
Awesome. Well, thank you very much. And I will put your website address down in the show notes as well
Thank
for
you very
anyone
much.
who was watching the replay. You can find it down there. And I'll say thank you again, Adrienne. It's great to see you again today.
Thank you, David. It's really nice joining you. Good luck. And I really like what you're doing here.
Awesome. Have a good
Take
one.
care.
Bye.
So, how can you learn more about buying, selling, financing, and managing small and medium-sized businesses? Easy. Go over to my blog site, davidcbarnett.com, where you can learn more about me and how I work with my clients. You can learn more about my books and courses that I've prepared for you. You can find out how to subscribe to my email list, the YouTube playlists, and more. There's literally hundreds of hours of content there, all for free, and I'd love for you to be my guest. Special thanks go to Mark Willis at Lake Growth Financial, today's video sponsor. Mark helps people better manage their personal and business finances through the Bank on Yourself insurance strategy. This is something I've done personally and I've seen others use it successfully for years. Go to newbankingsolution.com to find all the interviews I've done with Mark and learn more about the advantages of these programs. While there, sign up for a free consultation to learn what this solution might look like for you.